Morning everyone, my name's Hamish Lean. I'm Head of Rural Property at Shepherd and Wedderburn and a member of the firm's Rural Disputes Resolution team. This is the latest in our series of video webinars, and my topic today is looking at some of the problems arising from diversification on agricultural holdings, both from a landlord and a tenant's point of view. Diversification, of course, is the term used for a non-agricultural activity carried out on the tenanted farm by the tenant. Prior to the introduction of a statutory right of diversification in the Agricultural Holdings Scotland Act 2003, tenants could only pursue a diversified activity on the farm without their landlord's consent if it did not breach a specific prohibition in the lease and was on a very small scale. If a non-agricultural business became the predominant economic activity on the farm, the tenant was said to have inverted possession, and that could, in certain circumstances, lead to the loss of the tenancy entirely. However, since 2003, agricultural tenants in all forms of agricultural tenancies, whether secure tenancies or fixed duration tenancies under the 2003 and 2016 Acts, have a right to diversify, subject to following the correct statutory procedures. Now, of course, as we all know, there is a wide range of diversified activities carried out on tenanted farms across Scotland, and of course, those activities are carried on sometimes with more and sometimes with less formality, and some have been long pre-existing since prior to the 2003 Act. Some are carried out in accordance with the letter of the 2003 Act, and some have started informally since 2003, but without having gone through the statutory procedures. The practical questions that I want to look at this morning involve how to deal with all of those situations. How do you treat the diversified activity for rental purposes, for example? How do you best manage and run the diversified business if you're the tenant? What do you do if you're the landlord faced with a diversification notice? And what do you do if you want to bring an informal diversification to an end, if you're in the landlord's shoes? So, first of all, a quick look at the statutory framework as set out in the 2003 Act. For those of you who enjoy reading statutory provisions, perhaps that is just me, they can be found in Part 3 of the Act, sections 39 to 42. A tenant who wants to diversify must first of all serve a notice of diversification on a notice period of not less than 70 days. The notice has to do a number of things. It's got to specify what the non-agricultural purpose is, obviously enough. It's got to detail the land or the buildings that would be used for that purpose and any changes that the landlord is going to make, the tenant is going to make to enable those business purposes, and the date on which the purpose will begin. When the diversification is for a business purpose, the notice has also got to specify how the business is to be financed and managed. The notice must also address the various grounds upon which the landlord can object. If a landlord receives a diversification notice, they have an opportunity to request further information from the tenant, and the tenant's refusal to provide that information is in itself a valid ground of objection. Otherwise, the landlord can object if it reasonably considers that the intended use would lessen significantly the amenity of the land or the surrounding area, if it would substantially prejudice the use of the land for agricultural purposes in the future, if it would be detrimental to the sound management of the estate of which the land consists or forms part, or if it would cause the landlord to suffer undue hardship. The landlord can also object if it considers that the business that the tenant intends to carry on is not a viable business. As an alternative to objecting, the landlord can impose reasonable conditions under which the diversified activity can take place. If the tenant considers that those conditions are unreasonable, the tenant must then make an application to the Scottish Land Court for the conditions to be lifted, and the Land Court has the power to impose conditions of its own. However, if the landlord makes an objection, the landlord must then follow up the objection with an application to the Scottish Land Court within 60 days of having made the objection, and if it doesn't do that, the objection falls by the wayside and the tenant is entitled to proceed with the diversified activity. The onus to make the application to the Land Court in the face of an objection was originally on the shoulders of the tenant in the 2003 Act as originally enacted, but that was one of the reforms introduced by the Land Reform Scotland Act 2016, which firmly placed the onus on the landlord. Now, a recent case in the Scottish Land Court, Esselmont v Fife, it's available on the Scottish Land Court's own website. It's a decision from 2015. Established two important principles of how the diversification rules work in practice. The first rule is that the tenant isn't able to use the diversification procedures under the 2003 Act to gain retrospective approval for a diversified activity that the landlord is objecting to. Remember, a few moments ago I explained that if the tenant wants to carry out a diversified activity, they must give a notice to the landlord on at least 70 days' notice, specifying that it's their intention to carry out the diversified activity. The Land Court found in Esselmont v Fife was that the tenant couldn't use a diversification notice in order to gain approval for something that he'd been carrying out for, in that case, several years. The other main finding of Esselmont v Fife in that particular case was that the business that the tenant proposed to carry out the diversification notice had to be financed and managed by the tenant themselves. In Esselmont v Fife, the diversified business was a conservatory and double glazing business, a very successful business in fact, but the tenant, Mr. Esselmont, conducted the business via a limited company. Now, he and his son were the directors of that company, and he was the sole shareholder, and therefore he had the controlling interest. And it was argued on his behalf that, in essence, he was actually running the show and that he was financing and managing the business himself. The Land Court did not accept that argument. It pointed out that the limited company was a separate legal person in the eyes of the law, and therefore it could not be said that the business was being conducted and financed and managed by the tenant. So that was an important clarification of the law, because previously many commentators had taken the view that conducting the business via a wholly owned limited company was permissible. And in fact, in Esselmont, the landlord was able to have the limited company removed from the farm, and in related proceedings, that the Land Court went on to find that the tenant had abandoned active farming altogether, and therefore the tenancy had lost the protection of the Agricultural Holdings Acts, and that led to the eventual loss of the tenancy, and Mr. Esselmont having to give up occupation of the farm. An unresolved question arising from Esselmont v Fife is to what extent the tenant can use an existing family farming partnership to run and finance the diversified business. Now, in another context, the Land Court has found it to be entirely unobjectionable that a family farming partnership has paid for tenants' improvements on a let farm when it was dealing with quantifying compensation to be paid by the outgoing tenant. The Land Court wasn't interested in an argument by the landlord that it wasn't the tenant who had paid for the improvement, it was the tenant's family farming partnership. may be the case that a farming partnership financing and managing a diversified business would be acceptable to the landlord. I suppose if the tenant makes it clear in his or her diversification notice that the partnership will be involved, and if the landlord doesn't object to that, that would probably be sufficient to see off any complaint by the landlord at some future date about the way in which the business was being financed and managed. However, if the tenant does have to finance and manage the business under their own steam, that can cause real problems in relation to a prospective diversified business. There might well be a positive economic opportunity on the let farm to pursue some non-agricultural business activity, but the tenant might lack the skills to be able to pursue it. They might not want to expose themselves to the financial risk of running the business. They might not have access to capital to allow the business to be properly financed to make it a viable enterprise. If that is the case and the business isn't sufficient to allow the tenant to employ a manager, then it's likely that the only way that the tenant will be able to proceed is by seeking the landlord's consent. And it might very well be the case that the landlord will consent, but subject to the land or the buildings to be used for the diversified business being taken out of the agricultural tenancy and then let back to the tenant or the tenant's business vehicle on a separate, wholly commercial lease. From a landlord's point of view, that might be a very satisfactory outcome, and it might ensure a commercial rent is payable for the use. From the tenant's point of view, especially in the four square walls of a fully secure tenancy, the implications of losing what might be an important piece of land or building from the security of the tenancy itself would have to be properly considered, and at the very least, the commercial lease would have to be granted for a sufficient period of time to make it worthwhile the tenant investing in the venture in the first place. Now, it's often the case, like the situation that prevailed in Esselment v. Fife, that the diversified activity has been carried out for many years and long before the 2003 Act introduced the statutory diversification procedures. Unless there is a high degree of trust and confidence between the landlord and the tenant, the Esselment v. Fife case demonstrates that from the tenant's point of view, such arrangements can be extremely precarious. A tenant would be well advised in those circumstances to obtain written confirmation from their landlord that the landlord has no objection to the diversified activity taking place. In a worst case scenario, where a landlord declared that they wished the diversified activity to stop, and where the tenant couldn't avail themselves of the diversification procedures under the 2003 Act, perhaps because of similar reasons as existed in Esselment v. Fife, then it seems to me that the tenant would have to stop operations completely, would have to reinstate the land and the buildings back to their original state before the diversification activity started in the first place, and then, in effect, start from scratch by serving a diversification notice. Now, the expense and the disruption to the diversified business itself might be catastrophic, and the whole exercise might be completely unworthwhile. Another question that I'm often asked about in the context of diversification is the extent to which the tenant is allowed to sublet any part of the farm in pursuance of a diversified business. Now, subletting is permitted under the 2003 Act in relation to diversification, but only as an ancillary to the tenant's diversified business itself. An example which the Land Court has given is, for example, where a tenant establishes a golf driving range, it might very well be permissible to sublet a small part of the range to a golf professional to establish a golf merchandise shop or similar. However, the Land Court has also been very clear that subletting surplus housing on the farm on a private residential tenancy basis is not a diversified purpose. However, against that, establishing holiday chalets or a holiday letting business using surplus cottages does appear to fall within the realms of permitted diversification under the 2003 Act. The next question that I want to consider then is the correct rental treatment of the diversified activity. Under the current rent review test, as provided in section 13 of the Agricultural Holdings Scotland Act 1991, which of course is a qualified open market test, the question to be asked is what rent a hypothetical tenant would offer if the farm under review was available for let on the open market as at the next rent review date. Now, it seems to me that the fact that the sitting tenant had gone through the diversification procedures under the 2003 Act and was conducting a viable diversified business on the let holding would undoubtedly have an impact on the rent that the hypothetical tenant was likely to offer, taking into account the fact that they would have access to that diversified income stream. However, the improvements that the tenant had carried out to the farm to allow the diversified business to take place would have to be discounted and left out of account. In effect, the hypothetical tenant would be likely to make an offer of a higher rent because of the opportunity to pursue the diversified business. I've sometimes come across in rent review negotiations a landlord taking the position that even where the sitting tenant is not pursuing a diversified activity, the fact that the opportunity to do so exists should in some way be taken into account for rent review purposes. In my view, that's quite incorrect. It is right that the fact that an existing tenant has made use of the diversified procedures to establish a viable business is something that should be taken into account, but it is not something that should be assumed would be the case of every hypothetical tenant, unless, perhaps, it could be shown that every other let farm in the district had some diversified activity or other being carried out on it. However, under the new productive capacity rent review test to be introduced by the Land Reform Scotland Act 2016, whenever that is actually brought into force, the rent to be paid in respect of the diversified business will be the open market rent payable for the use of the land and the fixed equipment provided by the landlord. And that would automatically discount the tenant's own improvements, but that open market rent will be a commercial rent. It's unclear, however, when that new test will be introduced. So, everyone, thank you for your attention. That concludes my remarks on diversification and some of the common problems that I encounter. Hopefully you'll be slightly better armed to tackle them yourselves. You know where we are if you need formal legal advice. I also hope that you will sign up to the next seminar in the series taking place on Wednesday of next week about wildlife crime and sheep worrying. Thank you for your attention. Goodbye.